Okay, it says live YouTube. Are we ready? I'll go.
It's still
Let's go.
thinking.
Well, it says live YouTube.
Okay, yep, go.
Okay, great. Welcome to this morning's session of the Kansas Court of Appeals by Zoom. This will be our third Zoom session that we've done as a court. Starting this month, actually, all of our oral arguments are going to be by Zoom. So we're hearing arguments all day today. Another panel will hear arguments tomorrow, another on Wednesday, and another on Thursday. And I believe at this point that that's probably how our oral arguments will continue through the end of the year. For anybody joining us, welcome. There are a lot of awful things that have been happening related to COVID and the closures, but this ability to Zoom oral arguments has really got some positives, I think, that may remain after as my granddaughter says, after the virus leaves. So it allows your clients to watch. It allows you to avoid having to travel to Topeka or to wherever we're hearing oral arguments. So anyway, we're happy you're here, and we're happy we're glad you were all so willing to learn this new method of hearing oral arguments. All right, I'd like to introduce the panel today. To my right now is Judge Kim Schroeder. Judge Schroeder has been on our court for several years, and he is from Hugoton and was a district court judge out in Hugoton for several years. And way down at the bottom there is Judge David Bruns. Judge Bruns and I came on the court at about the same time. Judge Bruns was a former Shawnee County district judge and harkens from Kansas City, Kansas originally. And I'm Karen Arnoldberger. I'm the Chief Judge of the Court of Appeals. I've been on the court for about 9 years, 9.5 years, I guess. I was an Overland Park judge before coming on the bench, and I too am originally from Kansas City, Kansas. So with that, let me tell you a little bit about how we will proceed. We have read the briefs in your case, and I think we've all probably read at least a part of the record in your case. So you don't need to, you only have 15 minutes each to argue, so you don't need to spend a lot of time going over the facts, although I will give the appellant, Mr. Rinkenmeyer, I'll give you a couple minutes additional to just kind of lay out the facts for anybody that might be watching. But I'd also let you know, those that are watching, that because we have read the briefs and are familiar with the case, the attorneys will be given a chance to argue, but we may interrupt them from time to time and ask them questions. So they've got to be prepared on the fly to answer questions that we may bring to them, but it's questions that we've determined are important for us in trying to make a decision on the case. So with that, if the parties would state their appearances, please. First for the appellant.
Your Honors, this is Troy Rinkenmeyer on behalf of the appellant.
Okay, and for the appellees.
May it please the court, Richard Billings appearing on behalf of Dr. Bradley Steuwe and Freed Enterprises, LP.
Anybody else?
If it please the court and counsel, Cynthia Shepard on behalf of C&W Ranch and Joel Wimer.
And Your Honor, Michael Hughes on behalf of RJ Fencing, also known as Hertig Farms.
Okay. All right. Thank you very much, Mr. Rinkenmeyer. You may proceed.
Thank you, Your Honors. If I could reserve 5 minutes for.
Oh, yes. Thank you.
That'd be great.
Absolutely. Go ahead.
So, all right.
Here.
Okay. So as you have stated, I'll summarize some basic facts that are applicable to the issues on appeal at a minimum. My client owns a farm in Kansas that was used solely for hunting purposes. They acquired the farm in roughly 2005, and they've only used it for hunting in those years since then. the most of the defendants, other than Hertig, they own and lease the land adjacent to our farm in Kansas. They use it for multiple purposes, from what I understand. They approached my client about the possibility of cutting down a hedgerow. And the importance here is that the land is an open area of land. However, on the perimeter of the property, there is was a thick hedgerow of trees. They were approximately 70-year-old trees, very mature, irreplaceable trees. And the point of the hedgerow, the significance of the hedgerow is that it created a natural habitat for animals to gather on the property, which made the property as a whole good for hunting. The hedgerow itself is what made the whole property good for hunting. Without that, it loses most of its hunting value. The defendants, Wimer, leased the property from defendant Freed Enterprises. The defendant Wimer and the defendant Freed Enterprises together, or I think Mr. Wimer actually spoke on behalf of them, but he asked my client if they could remove the trees and cut the hedgerow down. And my client clearly specifically said no, because that's what we need to keep for our natural habitat. And they disregarded that statement and just cut the hedgerow down anyway. And these trees, again, were mature trees or irreplaceable trees. And that's where the lawsuit, found its way to the courts. And the claims we filed were for negligence, gross negligence, conversion, and trespass. And so Hertig, the defendant Hertig, is here because they were the company that was engaged by Wimer and Freed to cut down the tree row. So that's kind of who the parties were in their relationship with the transactions at issue. So we filed the 4 claims, and then after initiating the action, we obtained 2 expert opinions from our certified arborists as to the value of the trees. And the value of the trees, it's relevant. It's important to note that the opinions were opinions on the value of the trees rather than the replacement cost of the trees, as these types of trees are irreplaceable. They are large, old, mature trees. So we obtained the expert opinions on the value of the trees, and then thereafter, the defendants jointly filed a motion in limine to preclude our ability to introduce those expert opinions into evidence at trial, and the trial court granted that motion. And then thereafter,
if I can stop you for a second, both parties rely on one particular case, Evelyn versus Lily, I think, something like that, to make their case. And in that case, the court talked about, or Evanson versus Lily, the court talked about the fact that the general measure of damages for trees would be the value of the property before the trees were cut down versus the value of the property after the trees are cut down. Because it's my understanding, at least the facts of this case indicated that the whole value, you've indicated from your pleadings in the beginning that the value of these trees are over $1 million. But the value of the property, the land itself, is significantly less than that. So that's why there was the motion in limine to prevent you from bringing in evidence of $1 million value to trees. Is that correct?
Correct, in that the motion in limine was the argument made in the motion in limine and addressed by the court in its order was that the replacement cost of the trees was not a proper measure of value for permanent damage to the real estate, but rather the general rule is the appropriate measure of damages. as opposed
And
to.
are you still arguing that the $1 million is appropriate in this case?
Your Honor, what we are arguing is that under the Evanston case, because the trees had intrinsic value to my clients, then there's the flexible rule applies. Under the flexible rule, multiple theories of value can be introduced to the jury. One of those is specifically addresses that one of those measures of value is the value of the trees themselves, but then other measures of damages can be introduced as well, such as the replacement cost for saplings. We produced in discovery a bid provided for approximately $80,000 to replace the saplings for the same number of trees that were there before. So we intended to introduce that as evidence to the jury, the replacement cost of the saplings, the value of the mature trees that were removed per the arborist's valuation, as well as other testimony, such as testimony about my client's view of the value of their hunting activity that was lost.
And what did they indicate the value of the lost hunting was?
They have not had the opportunity to indicate that because there's never been depositions in this case. They have never been asked that question to quantify what the value of the hunting is.
I've got a question on that. Wouldn't it have been your responsibility to come forward with any evidence such as that in response to the summary judgment motion? Seems to me from reading this decision that the district court thought you did not come forward with sufficient evidence to defeat the summary judgment motion.
We came forth with of course, the expert opinions on the value of the trees as one measure of damages. We did state clearly throughout the process that the damage that we have lost is the value and the loss of the hunting is a primary loss of our damage. And we never quantified that because we anticipated to provide that to the jury at the trial.
But you recognize that in response to their statement of uncontroverted facts, that would have been the opportunity. You presented an affidavit regarding a reduction in the quality of hunting. Wouldn't that have been the time to also put in that affidavit what your owner thought was the value, what the saplings were, and any other evidence that you thought could defeat summary judgment?
Well, we had previously already introduced it. We had previously already produced the bids for the saplings, for example. That had already been produced to the defendants in discovery.
But was it put in the response, in the Rule 141 response to summary judgment?
We did not put that in there, Your Honor. We did not put in a quantified value of the value of hunting. But again, that's one piece of evidence, the value of the hunting activity that was lost. Per Evanston, additional evidence that could be introduced is the value of the trees, for example, as well as the value of the saplings.
Well, one of your major claims in your petition, you claimed the $1 million+ in replacement costs, and then you claimed the value of lost hunting. Aren't the defendants entitled to know what you're seeking there?
They are,
we don't have trial by surprise generally.
They are, Your Honor. Typically, they would ask that question in discovery via written discovery or deposition. They never took any depositions in this case. They never asked that question in written discovery.
I have a question.
Oh, go ahead, Kim.
It appears to me in the defendant's pleadings, they make an allegation that the trees are not on the plaintiff's land and that issue is unresolved. Is there a remaining question that the trees did not exist on plaintiff's land?
I don't believe so. There were some trees that may have fallen on the defendant's land, but there is a question as to where the border of the land falls. We provided an expert opinion as to where that border is, and most of the trees fall on the appellant's land.
Are you saying you had a survey, or how did you determine that?
We had a survey. Our surveyor came in and provided expert opinion as to where that border sat. And I believe, I don't want to speak for the appellees, but I believe in just informal discussions that it was clear that regardless of even their view of where the border sat, part of the trees were on the appellant's land.
Well, part. what part are you referring to? Half, a third, 10%?
We believe 90%.
But is there a dispute about that? Do they believe something else?
There's a dispute about where the border sits. And so we've not done an actual, okay, how many trees fit on each side of the lane of the border per their view versus our view. We viewed nearly all of the trees we're on. Per our expert opinion is whereas the border sits, we believe that nearly all of the trees fell on the appellant's land.
Land. Okay.
And do they have an expert that says something differently?
They've got an expert that shows that the border is in a different place. It was not, if I recall, it was not by survey. It was an opinion of more of a landmark based survey. But again, I don't want to speak for the appellants on that.
Well, I'm not asking you to. I'm just, but what are you talking about? A landmark? Are you talking about the blades in the ground?
I'm talking about like a pile of rocks that were sitting there on one corner of the property.
They went out and had a hard time figuring out where the corners were, right? So they were just making some suppositions based on where there were some rocks and.
That's my understanding. Now, our expert used more of a scientific method to obtain where the border sits.
Okay.
Okay. I've got a couple questions about basic facts to make sure I understand this. Your client is a limited liability company, is that correct?
That's correct.
And who are the members of that?
There are 5 members that use the property equally together for hunting purposes.
Does anyone reside on the property?
No,
Okay. And then is this simply used for personal hunting or is it used for commercial hunting or both?
personal hunting.
So just the 5 members of the LLC and anybody that they would invite would be the only ones that would hunt on that property?
That's correct.
So there's no income generation from hunting on that property, is there?
That's correct.
And did your managing member of the LLC who submitted the affidavit in response to the summary judgment motion, did he render any opinion as to the value or the damages?
He rendered the opinion as to the $1 million for the value of the trees. And then,
In response to summary judgment?
and the replacement, the sapling, the bid for sapling replacement.
Was that in response to their statement of uncontroverted facts?
They never asked that question in the uncontroverted facts. They merely asked the question as to what was the value of or do you know what the value of the land overall was before the removal of the trees and the value of the land after the removal of the trees. They never asked what was the value of the hunting, nor what was the value of the trees, nor what was the sapling replacement bid. They only asked what was the value of the land overall before and after the.
Well, as you know, when we're dealing with summary judgments, we have to stand in the same shoes as the district court and only review that information that was provided in the statement of uncontroverted facts. In your response to that, it's not a question about what did they ask or not ask. It's what did they allege in their statement of uncontroverted facts, and then what did you provide evidentiary to respond to that? So what I'm trying to get at is, did the managing member of the LLC state in either his affidavit or anything that you submitted in response to the motion for summary judgment, his opinion as to value, his personal opinion?
He did not, Your Honor. I guess our view of this is that the value of the personal hunting is one measure of damages per Evanston. Multiple measures of damages are available. If our view is, as argued at the lower level, if all of the there were 3 uncontroverted facts provided by the appellees, assuming all 3 of those facts are true, that does not defeat the Evanston issue. The Evanston case being that we have multiple theories of damages that were provided in discovery, such as the sapling replacement costs, such as the value of the trees removed, et cetera. So assuming all 3 of those facts were deemed true, we believe that the appellee's argument still fails, that the summary judgment still fails because there are questions of fact outstanding for the trial court to determine, because that was only the value of the hunting itself was only one measure of damages. And we provided discovery other ones.
Okay,
I'm sorry, I guess I'm a little confused. But in response to the motion for summary judgment, Did you allege the other issues or only the $1 million value of the trees?
We alleged that there was damage to, that there was reduction in the value without quantifying that reduction in the value of hunting. We responded that, that's what we responded, was that there was a reduction in the value of the hunting without quantifying that value. But I guess our point is that even if all of those points are deemed true, because they were uncontroverted facts, we still feel that the summary judgment should be defeated because there are other facts that still continue the case, such as the value of the trees. And
But did you bring those forward in your response? Did you bring those other facts forward and cite specifically to the record in your response to summary judgment?
I did not, because they didn't ask the question. They only asked what was the value of the land overall. I'm not sure where I would have brought that forward at, because they asked what was the value of the land overall, which is not, in our opinion, relevant given the Evanston case.
Okay, I understand. That's not my understanding of Rule 141, but I understand your position. Let's move on to one other question that I wanted to ask, and that has to do with, wouldn't there at least need to be somebody to establish a causal connection between the loss of hunting and complete replacement value in order to obtain those damages?
Well, from reading the Evanston case, it cited Railroad versus Nolan, et cetera. And in those cases, they provide that the jury should be instructed as to the value of the trees, as well as the value of the land before and after the damage, as well as any other alternative measures of damages. And then the jury can decide what that amount should be. In fact, it stated that specifically in Evanston, it cited a case stating that if they are far, if the value of the trees is far outweighed by the value, I forget the word they use, but if the trees are not comparable to the value of the actual loss, then you should introduce both to the jury, and then the jury can make that determination as far as what the amount should be.
But did you have any, even if you did that, did you have any evidence that was presented to the district court at the summary judgment stage showing a causal connection between the claimed reduction of quality level of hunting and the fact that you felt that these were so unique that the trees were entitled you to replacement value?
I mean, we argued that the only purpose of owning the land had always been solely for hunting, and now that was fully destroyed.
So nobody could hunt on that property now. Is that what you're saying?
But it's an open field. It was a bird hunting. It was used for bird hunting, and the hedgerow created the habitat for birds.
And there are no more trees there now? They took down every tree?
The tree row is gone. I think there are maybe some in the middle, sparingly around the property, but there's no hedgerow left.
Can you still hunt the property though? I mean, is there still, I mean, even though there's not as many birds, can you still hunt the property?
Well, as my clients responded in the summary judgment, no, that it was fully destroyed.
All right.
So that there's no hunting, just so I'm clear, there's no possibility of hunting now. So it's not a reduction in the amount of hunting, that there's just now zero hunting possible.
I guess, Your Honor, I mean, you can always go to the land and wait for an animal to cross the land. I can't say that you can't, but I mean,
that's kind of what hunting's all about usually, especially deer hunting. But anyway.
Well, I understand. No, I mean, I guess what they responded in the summary judgment was that it was severely reduced. It was severely the value of the hunting activity was severely reduced. I think those are the words we used.
So the name of the company is Ringneck. So I assume you're hunting pheasants.
That's correct.
And isn't the balance of the quarter or approximately 160 acres still native grass?
The remaining of it is mostly open field, yes.
But is it native? I mean, is it something native to the area, or did they go plant it to a particular type of grass?
No, it's native to the area.
And you're saying your clients are saying that birds won't live on that native grass?
Well, I believe that they will, but they're not going to be attracted to that grass because without the hedgerow, they won't. These birds typically go to the areas where there's hedgerows for protection, and so that's what brings them to the land is the existence of the hedgerow itself. and then they may walk around maybe they'll migrate around the land with native grass, but they won't be attracted to that parcel of land nearly as much as they would have had there been a hedgerow. When they go hunt, they go hunt near hedgerows, is where you go hunting for pheasant, because that's where they come.
Do you have an expert to testify to that, or did you obtain an expert that had that opinion?
No, we've not obtained that.
Okay, I've let you go way over at this point. So let's move on. I'll give you a few minutes in rebuttal.
Your Honor, if I could correct the statement real fast. I think you asked earlier if there was any income producing property or income. They do get CRP income. I want to make sure I don't mislead you.
Okay. Okay.
But not related to the hunting, related to land conservation.
That's correct.
Okay, thank you.
All right, Mr. Billings.
Thank you, Your Honor. I'd first like to start to say that the plaintiff had the burden in this case to prove both liability and damages. So there was an issue with respect to liability in this case. None of the defendants admitted any liability. There were competing experts as to the boundary line, and there was a boundary line dispute. It was the defendant's joint position that it was appropriate for them to remove these trees due to the location of the boundary line and an easement on the property. But recognizing prior to
What kind of easements?
well, there was an old easement that allowed access for purposes of both ingress and egress, and it had some other terms in there. And this was the area where the hedgerow was an old access road that allowed people many years ago to use that road to access some of the back portions of the property.
Okay.
And so
Recognize property or the plaintiff's property?
It was at the back of my client's property. And so the owners of the lands that Ringneck purchased the property from had given my clients an easement of that area. But because liability was an issue, we focused on, since they also had to prove damages, what was the evidence presented of their damages? And from the beginning of this case, they've always only sought this over $1 million for the replacement costs of hedge apple trees. I mean, these were naturally growing hedge apple trees located on their property of 160 acres. And this was a row of about 300 yards of hedge apple trees. And so it was their burden to prove the amount of their damages. And what I think first is an important thing to note is that it was always about replacement costs. The expert opinions that the appellant designated were clearly, these are what the replacement cost is. Here's how we arrive at the replacement cost. We went to a nursery and found what a 1/2-inch diameter Osage orange or hedge apple tree would cost. And then we multiplied that cost by the diameter of the trees that were cut down, and that equals our replacement cost of the mature trees. I mean, they got to $1 million because by doing that math, they came up with over $56,000 for one tree. And I think there'd be a lot of people that own agricultural land here in Kansas that would love to find out that their hedge apple tree was worth $56,000. This was about obtaining a windfall from the beginning. They had, before suit was filed, consulted with a forensic consultant from Kansas State University to obtain an opinion as to what is the loss of this wildlife habitat on the land. And Mr. Naughton replied back to them and said, it's $1,600. The plaintiff made a choice. They decided in this lawsuit, they were going to go for $1 million plus or nothing. And they made that choice when they designated their experts in this case, and they only designated the experts Well, there was one expert that said this is the replacement cost of over $1 million, and the other expert said, yeah, I agree with you. And so really it's the same opinion between the two. But they chose not to designate the one person that told them that they had at most a $1,600 loss in this case. And the appellant never, in response to the motion in limine or in response to summary judgment, ever even attempted to make any argument that there was any monetary damage that they suffered other than this over $1 million in replacement costs.
Is
so-
the appellant correct? Did you never ask what he estimated the value of the lost ability to hunt was? Did you never ask that question?
We served written discovery early on in this litigation, Your Honor, where we asked them all kinds of questions about their damages. Those are attached to our motion for summary judgment. We asked them about the value of the land before and after. We asked them about the value of the trees before and after, which both of them, the plaintiff themselves said, basically, we don't know. We're going to leave this up to experts to offer opinions. And then we asked them, tell us what damages you're claiming in this case. And they said, we're claiming the $1 million in replacement costs. And then we did a catch-all of, are you claiming any other financial losses as a result of this? And they said no. And so I don't think that we're under the obligation to take any depositions in a case when the rules of civil procedure provide methods of discovery. They don't mandate that we take depositions to help build their case. I mean, we can serve written discovery in an action, and if we're satisfied with the information, that we have enough information to defend our case at trial, then we can do that. And really, when it came to the summary judgment stage, our strategy of not taking a deposition really would have only aided the appellant in that they had a blank slate to write whatever they wanted into an affidavit because we hadn't taken their deposition, and they chose not to. I mean, when we get to summary judgment practice and jointly as the defendants, our whole position was plaintiff has failed to produce any evidence of damages on any of their claims. That was their time to come forth and say, district court, here are our damages. These are what we want the jury to consider. It wasn't, well, we want to just go to trial and then we'll start putting evidence before the jury and let them make the decision. I mean, at the summary judgment stage, they're required to show that there's a genuine issue of material fact. And I know all of you have read the summary judgment pleadings, the district court's decision, and what the district court decided was, after reviewing the submissions, there was simply no genuine issue of material fact as to damages because the appellant failed to come forth with evidence to support their damages at this stage. I mean, in reality, they didn't even set forth their claim for replacement costs in response to the summary judgment motion. I mean, had we not filed for summary judgment and the case moved forward to trial, they would have been required to proffer their evidence of their replacement costs from these two experts to even preserve the issue for appeal. But at the summary judgment stage, they made the decision that their only evidence of damage that comes down to one sentence in their affidavit, which is the removal of the trees resulted in a reduction of the quality level of hunting on the land and therefore we're damaged. It'd be like a personal injury case where a summary judgment motion was filed and the response was, I hurt my knee in this accident. Well, how did you hurt your knee? I mean, there's no evidence of how the level of hunting was diminished. I mean, some of the things that Mr. Ringneck has told you on arguments today are just simply not in the record. There's nothing in the record that they used it for bird hunting or that they can't hunt anymore, or that it was virtually destroyed. I mean, there was nothing to, yes.
Even if it was in the record, it's not, we're in the shoes of the district court, I would believe, on reviewing a motion for summary judgment. is it our obligation to search through the record and find these things, or do we simply review the motion for summary judgment, the response to motion for summary judgment, and whatever guidance, although we don't really have to give it any, that we find in the district court's opinion? It seems like that summary judgment's the time to come forward with the evidence and specifically cite where it's at in the record, and not for us to go on a hunting expedition to try to find it.
Oh, and I completely agree with you, Judge Bruns. There are many cases, appellate court cases, where it specifically says it is not the district court's obligation or the appellate court's obligation to search the record to try to create or find that issue of fact for the appellant. It is the appellant's obligation at the summary judgment stage to set forth at the summary judgment record what their evidence is of damages. And
one thing does bother me in this opinion as I read it, and I know that we don't have to give it any weight, but reading the opinion, it looks like the district court judge is talking primarily about negligence. What's your position as to all these other claims? Were they all included in your summary judgment motion?
Yes, in our summary judgment motion, we said plaintiff has no evidence of damages on all the claims.
And would the damages be different from one of the claims versus the other?
I mean, there are in our brief to the court, we addressed some of those different damages. With respect to conversion, it was my client's position in this case that conversion wouldn't be an appropriate cause of action because trees are not personal property. They're part of the realty, and so thus there couldn't be a conversion claim. But with respect to a conversion claim, it would again be the value of the property converted apart from the land, and there's just no evidence in this case regarding that. And with respect to their claim for trespass, there would be at most a claim for nominal damages. But when we filed that summary judgment motion and we said plaintiff has no evidence of damages on any of their claims, again, that's their responsibility to come forth and say, well, hey, we are making a claim for trespass. And in a trespass claim, we don't have to provide evidence of actual damages. If we prove the trespass, we're entitled to at least nominal damages. And our rules are clear that if a party doesn't raise those issues on summary judgment, then they waive those issues. And in fact, they've waived those issues on appeal, Your Honor, because when they filed their appellant's brief, they did not raise that in their initial brief to this court. It was only after we filed our brief, which addressed those particular issues, to say that doesn't matter because we made a summary judgment motion based on all claims, that they came forth in their reply and said, oh, yes, there is a conversion claim existing and that helps our cause, although there wasn't much of an explanation as to why. They didn't, again, even in their reply brief, address the claim for trespass. And so we believe that the appellant waived any claim for trespass or conversion. And that's because when you're faced with a summary judgment motion that says you don't have any evidence of damages on any of your claims, it's your responsibility to come forth with that evidence of damages. With respect to the Evanson decision, my reading of the Evanson decision is that it did not change longstanding Kansas law. It's been the law in Kansas for years that when you have trees removed from the land, that the general rule is that the damages are for diminution in value. But there are cases that are cited in our brief where if there is a separate and distinct value of the trees apart from the land, then that could also be an appropriate measure of damage. And our position,
Mr. Billings, the way I read Evanston, it's talking about the uniqueness of a tree. So for example, the cottonwood tree that was on the grounds of the state capitol that represented our state tree that unfortunately I think died, but that would be unique. Trees with sentimental value, I think they mentioned. And you probably noticed I asked your colleague there about whether any income was produced off of this, because I do think that the Evanston would potentially allow damages for income producing trees. And I think they use the example of fruit trees, but we don't have anything like that in this case, do we?
Absolutely not. And that is exactly where I was going with Evanston. They said, here's the general rule, but of course we can envision a scenario where someone has an orchard that is producing thousands of pounds of apples every year and generating income from those, that lost income could be an appropriate amount of damages. It could even be to the extent that we may allow a person that has an apple orchard to make a claim for replacement costs. It also talks about.
I
Go ahead.
understand the Lilly case and the diminution of value of before and after the value of the land, but that's not very satisfying. But, these people cut down trees off this man's land, and let's say the diminution in value is only $1,500. That's kind of a cost of doing business. It sends a message to people that want to go on your land and destroy it, that it's okay if they're willing to pay a few $1,000s to, and I know this is not a case in equity, but there's something not very satisfying about that, what, isn't he entitled to some damages?
Well, and I think the law provides that if he presents evidence of some independent value of those trees beyond the diminution in value, then yes, the plaintiff would be entitled to it. I mean,
so had he presented evidence that the value of hunting this, that we bought this property to hunt, it's not suitable to hunt anymore. Therefore, it may take us longer to sell it because there'd be no reason for people to buy it if they can't hunt on it. If he had presented that kind of evidence, then the case could go forward with that.
I think that there definitely are a set of facts that could be presented in a case like this with similar liability facts that would support a claim for damages for wrongful removal of trees beyond the diminution in value. And I think that's what Evanston is saying is, our facts are strikingly similar to Evanston,
right,
where what we have is a party who has decided to only seek the replacement cost. And in fact, in Evanston, they said, well, the quality of hunting was reduced on our land. And what the Court of Appeals and Supreme Court in Evanston said was, well, you didn't provide any evidence quantifying how that happened. And so, to the extent that Ringneck in this case has argued and pled that the hunting quality was reduced, I'm sitting here before the panel today, and I can't tell you how it was reduced in any way. And that's because Ringneck has made a conscious decision throughout this case not to provide that evidence. And so this is not the case that I believe our Supreme Court envisioned when they said there are exceptions to the general rule on damages for the reduction of value. I think your concerns are valid, Your Honor, but I think that a decision today affirming the district court would not preclude a plaintiff in the future that presented the evidence necessary to make those claims from making those claims. I just think it's lacking in this case, and it's a failure by the appellant to create a record on summary judgment to say that these are our damages. This is how we're going to prove our damages.
Okay, I've let you go a little over too, because I certainly let the appellant go over. I'll give you, a minute to sum up if you'd like.
Sure. I mean, I think just in closing, Kansas law disfavors windfall recoveries. And when we have a land that is at most valued $320,000, I think Evanston and the other decisions we've cited would say that even if there was a separate value of these trees, they have to be reasonable. And for it to be reasonable is not 3+ times the value of the land itself. And so I think in and of itself, the fact that they've attempted to claim over $1 million in this case just shows the unreasonableness of the plaintiff's claim for damages from the beginning. And so I think that the case law supports us with respect to what the proper measure of damages were in this case. And I think that the real dispositive issue here on appeal is that when faced with a summary judgment motion that took the position that you have no evidence of damages, the appellant failed to produce any evidence of damages in order to try to create a genuine material issue of fact. And absent a genuine issue of material fact, it was entirely proper for the district court to grant summary judgment to the defendants in this case. Thank you.
Thank you very much. Okay, rebuttal, I'll give you 3 minutes. You're muted. You're muted.
You're muted.
Okay, no, yeah. Abby, if you're on there, we need to unmute him. There you go.
Sorry.
Okay, go ahead.
Just to address a couple of points, Your Honors. Okay, the utility easement he addressed at the beginning, it specifically precludes removal of trees. That thing simply does not apply to this case. It's simply an access utility. Easement is all. I mean, and so that's really a moot point here. The expert opinion it's just a false statement to say that opinion is for replacement cost. The opinion it mentions the word replacement cost one time in a several page opinion. It repeatedly says the value of the trees are X. We've been asked to figure out the value of the trees. And it does say, the one time it mentions the word replacement cost, I'll quote, to find the value of a tree, you first have to look at the replacement cost to figure out the width of the base of the tree. And then from there, you go on to find the value of the tree itself. So this is not an opinion for replacement cost. You can't replace 70-year-old mature trees. There's no replacement cost because there's no way to replace that tree. This is the value of the trees removed. That goes directly to the conversion claim. The proper measure of damages for a conversion claim is the value of the property taken. So this is the appropriate measure for that. The windfall, we were not seeking a windfall. We intended to produce, as Evanson says, one measure of damages to introduce is the value of the trees. There's other things could be introduced as well. We intended to introduce the saplings, which we produced in evidence, the replacement cost for saplings, which is about $80,000. Evanson specifically addressed this issue of windfall. To prevent a windfall, you can instruct the jury both on the value of the trees removed, and specifically, if you look at head note number 3 in the Evanson case, it specifically says, and I'll quote, for purposes of determining tort damages, the value of trees separate and apart from the land, which is what we valued, may be an appropriate measure of damages if the trees had a separate or intrinsic value. Then to address that, Your Honor, the Evanson case specifically gave examples of what intrinsic value could be. It specifically said hunting. It says, if the value of the trees created a hunting value, then that is the intrinsic value we're talking about. And that can be found on the bottom of page 11 of the actual case itself. It said, had a trial court in that case, had Evanson's introduced evidence as to the specific value or evidence that the trees had value independent of to the land, such as picketing, recreationally, and hunting, then they would have been able to introduce the value of the trees into evidence. That's what we've stated from the very beginning was the value of the trees. The loss of the hunting was a damage to us. So the value of the trees themselves is one measure of damages to be introduced at trial. And so we did have evidence that could be introduced at trial. Whether it was a windfall or not, that's at least evidence that could have been introduced at trial. We also made clear we were going to introduce other evidence, such as the replacement value of the saplings. And then per Evanson, it specifically says that you should introduce both and let the jury figure out how to avoid. And Evanson said that you can introduce that you could be instruction to the jury that there should not be a windfall, and then let them figure out what their proper measure of damage is. So the trial court could have instructed the jury that we're not allowed to get a windfall. Here's the value of the trees per the arborist, and here's the value of the saplings being removed. Figure out the proper measure of damages. And that's my point. In discovery, they never did ask ever what the value of the hunting was. They never did ask that question. They asked what the financial losses were if there was an income producing property. It wasn't an income producing property. We said there was no financial loss because there was no income producing property. So they never asked what was the value of the hunting in their discovery.
Could you have answered that had they asked?
Of course I would have answered them. Had they asked, please.
So what is the value? What is that value? If you were to go to trial, what would you have presented as far as the value of the personal hunting?
My clients would have testified at trial that the value of the hunting was the entire value of the property to them, because that's the only reason why they own it, is to hunt.
And that could have been put in the affidavit by your client in response to summary judgment, could it not?
In response to summary judgment, they asked what was the value of the land before and after. And we said the testimony, we paid X dollars for the land, it was raw land, and then it was the value of the hunting was fully destroyed because of their actions. Hence,
summary judgment motions don't ask questions, that's interrogatories. I mean, summary judgment motion says, here's the evidence we claim they don't have, and then it's your duty to come forward with the evidence. You keep saying they didn't ask. They don't have to ask anything in a motion for summary judgment, do they? They state their uncontroverted facts, and then they state their conclusions of law, and then you respond, come forward with the evidence that you would present to beat the summary judgment. I don't understand this. They did not ask in summary judgment.
I guess what I was referring to, Your Honor, is the uncontroverted facts. The statements of uncontroverted facts were never that you were not damaged. It was simply what's the value that we don't know what the value of the land before and after was, is what their statement of uncontroverted fact was. And we replied saying, you're right. We've never got an appraisal on the value of the land after the tree removal. We paid X dollars for it, but the loss here is the value of the hunting activity loss. And that's the full value of the land for my clients. That's the only reason why they've owned it since 2005 was for that sole purpose. And
well, hasn't the land dramatically increased in value? Isn't that another function of owning it?
I mean, we've never gotten an appraisal on the value of the land afterwards, because from our perspective, the value per Evanston, the value of the land before and after is not the relevant, isn't the measure of damages.
Is the value that was lost the value to the few acres that the trees set on and not the entire quarter?
Your Honor, we disagree with that, because the entire quarter was the value to my clients was solely the value of hunting. There was no other value to that property.
There's still another 150 plus acres for them to hunt birds on.
Yeah, but the birds would not gather to that property because there's no habitat left for them to gather to that property.
So what prevented you from, in response to the summary judgment motion, saying the whole point we bought this was for hunting, now we can't hunt, so we have lost the entire value of the land at $320,000?
Your Honor,
wouldn't that have put forward then something for them to respond to then?
Your Honor, we did. Our response to their statement of uncontroverted facts was that point, that the value of the land to us was the value of the hunting, and it's been fully lost because the tree row is gone. And we've already put in evidence the value of what we paid for the land.
Okay, all right. Okay, well, thank you all very much. I've let you both go over quite a bit, but this is a very interesting case, and we will give it our undivided attention. Our rule on the court is we try to get all our opinions out, meaning submitted on a Friday to file within 60 days of today, and that is still our intention. So you will hopefully hear something within the next 60 days on our decision. But thank you very much.
Thank you.
Thank you.
Thank you,
Thank
Judge.
you all.
Good day.
Thank you all.